So I've discussed in a few other videos about negligence and how that can be a cause of action both contractually and just at common law. And negligence, as we've explained, you have to prove three things. That a duty of care was owed, there was a breach of the duty of care, and that as a result of that breach you suffered some loss. And I've covered duty of care on a few occasions, but what do we mean by breach? What's the sort of, what does that actually mean? Well, the standard test it's that word reasonable again, and it's that you fell below the standards expected of a reasonable person in those circumstances. So to use the obvious everyday example, when you're driving, you are expected to drive to the standard of a reasonable driver. Now the courts are quite clear. It's not a guarantee of perfect driving. All that you can expect from any other road user is reasonable driving. And that's a test that applies to everybody. In that circumstance, for instance, the mere fact that somebody is an expert professional driver, they're not actually held to a higher standard if it's just general common law negligence. Similarly, you can't say that just because you're not quite as good a driver, you should be held to a lower standard. As the courts eloquently put it, it is not a defence to say you are doing your incompetent best. In some situations, though, there can be different standards. Say, for instance, you're in an accident and I come along and try to do, my first aid bit. I won't be held to as high a standard as if you actually attended hospital and were treated by a proper medic, because you can expect those people, to exercise more skill and care. Also, the law, when it comes to incompetent rescues, the law basically treats rescuers a little bit kindly because they don't want to discourage people from, trying to save lives. So even if you make a situation worse, unless it's sort of something that's really egregious. I mean, I suppose yanking a motorcyclist's helmet off after an accident, because everybody should know not to do that. But, say for instance, I throw a life ring in to try and rescue somebody who's fallen off the pier and I just hit them on the head and they drown. I've made the situation worse, but I've probably not been unreasonable in that particular situation. So that's the sort of general thing, falls below the reasonable standards. I mean, like I say, there can be some things where you will be held to a higher standard. So, it might be fell below the standard of an amateur, or fell below the standard of a professional. But generally speaking, you want to get that higher standard if it's something where there is a higher enhanced duty of care. Say, for instance, you are in hospital, you expect the medics to look after you professionally. But of course, if you just put that on a claim, they were negligent, that doesn't really help the court decide. So when you do claim, you set out what we call particulars of negligence. And you actually list everything that you think they specifically got wrong or should have done better. So say, for instance, it's a slipping case in a supermarket. You'll see things like failed to have a safe system such as to prevent spillages, failed to have a system to identify spillages quickly, failed to treat the spillage quickly, failed to put up adequate warning signs pending the spillage being cleared, that sort of thing. Sometimes, though, either you don't know what actually specifically they did wrong, you just know something did, or it's something where you can just go, something must have gone wrong. So if you come onto my premises and, a piano falls on your head, then arguably that's not something that happens unless somebody's at fault. So then you can plead what we call res ipsa loquitur, sometimes just called res ipsa. And that's Latin for the thing speaks for itself. And as you can guess, the idea is, look, it's obvious, the thing speaks for itself. Pianos don't fall on people's heads unless somebody has screwed up in some way. So that's the general thing. We can look at sort of what we come on to consequential loss, because the mere fact there has been a breach, you still have to show that you suffered a loss as a consequence of that breach. And even if you do suffer a loss, it has to be tied to the breach. So if coincidentally somebody is negligent in the sort of breaching reasonable standards case, and you also suffer a loss somehow, you'd actually have to show that it was caused by that. So say for instance, on the motorway, somebody was a negligent driver and they swerved in front of you and you subsequently skidded off the road and crashed. If you're going to skid off the road and crash anyway, it was a slippy road or something, you might be able to argue that there's a braking causation. We also have these ideas of what we call contributory negligence. Yes, it was somebody else's fault. However, some fault of your own made the consequences worse. And that goes to deducting the damages. Contributory negligence used to be an absolute 100% defence, but now it's done in percentage terms. So say, for instance, you're in a car accident and you're not wearing a seatbelt. They knock the damages down for that. It's supposed to be that the contributory negligence, it's not just a penalty for not wearing a seatbelt or a helmet. It's supposed to show, this was a causative thing. So say, for instance, you're in an accident, you get knocked off your bike and you're not wearing a helmet, but you don't get a head injury. You can argue and say, well, it doesn't really matter. Sometimes, though, the courts do just apply a blanket sort of percentage reduction. And contributory negligence can actually be 100%. So they can say, yes, it was the other person's fault, but actually your own wrongdoing or your own negligence was such that actually all the consequences we can just put at your door. There's a couple of other factors that come into play actually with negligence. There's an interesting one that one factor courts have to take into account when deciding if somebody was negligent is, would it have a detrimental effect on an activity that you don't want to discourage? Say, for instance, and this has cropped up with the bouncy castle cases. Now, if you go to a professionally run fun fair, you expect the bouncy castle people to know what they're doing and all the health and safety stuff applies. So they are held to a higher standard than if you just put a bouncy castle up, in your back garden, you just rent it and don't have anybody supervising it. And we've seen some horrible accidents there. But the courts have actually been quite reluctant to find negligence because they've said, look, at the end of the day, bouncy castles are fun and kids enjoy them, and they don't just sound too grimly utilitarian, but a couple of kids being injured every year or every decade, it's worth it for the fact that lots of kids have lots of fun on bouncy castles, and we wouldn't want to discourage that. So that is actually somebody, if you're ever sued for negligence and you're providing an activity that's generally beneficial, it doesn't have to be a fun activity either, it can be sort of an essential activity. You can actually argue and say, look, you shouldn't hold me negligent because that would have a detrimental effect and that would discourage people from doing what I did. And overall, doing what I did is actually a benefit. I'm providing enjoyment for people, or I'm providing useful training. Say, for instance, you set up a mountain rescue school or something and people keep getting injured. They wouldn't want to discourage people from learning how to rescue people off mountains, something like that. Anyway, so there you go. As always, hope you found that vaguely useful, vaguely interesting. I found my old bridge. This is one I looked for ages, so I came back here to film and I actually forgot to bring the tripod. So I've just got the camera balanced on the little baby tripod. I'm going to pretend that was a deliberate artistic framing choice and I'm being arty. So, if you want, do all the, like, click, subscribe, share, click that notification item, whatever it's called, icon. That'd be great, because like I say, I am actually touting for subscribers at the moment just to try and get YouTube to work better. Not just for me, but for you. Actually, primarily for me, because apparently it will upload faster. So there you go. See you next time.